Put that down as donations.
Yeah, he's also, we go out to accepted students.
This today at my office. I read the whole start reading everything. When you look at this.
You ready? Okay. Want to welcome everyone to the Hillsborough Township Planning Board public meeting of April 10, 2014. Please join me in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The meeting has been duly advertised according to Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, the Sunshine Law. Roll call, please.
Mr. Wagner?
Here.
Mr. Julian?
Here.
Mr. Michon?
Here.
Mr. Connor?
Here.
Dr. Maruli?
Here.
Mr. Merdinger?
Here.
Mr. Peason?
Here.
Vice Chairman Cohen?
Here.
Deputy Mayor Burchett?
Here.
And Chairman Dr. Seuss.
Here. First item of business, disposition of minutes from the April 3rd meeting, which is last week.
All members of the board present can vote on this except for Dr. Maruli.
So moved. Second.
Any discussion? Roll call, please.
Mr. Wagner?
Yes.
Mr. Julian?
Yes.
Mr. Michon?
Yes.
Mr. Connor?
Yes.
Mr. Merdinger?
Yes.
Mr. Peason?
Yes.
Vice Chairman Cohen?
Yes.
Deputy Mayor Burchett?
Yes.
And Chairman Dr. Seuss.
Yes. Is there any business from the floor for items not on tonight's agenda? Seeing none, we will go to, well, I'll just mention right now, there is a piece of correspondence from you, from the SCPB, if you wish. And the item on tonight is the Glengarry Corporation subdivision application, file 14PB01MR, block 182, lots 10, 11, 12, 45, and 46. This is on 45 Hamilton Road. The applicant is seeking minor subdivision approval to reconfigure the lot lines. And this involves a subdivision and a redrawing of the lot lines of their property. No development is proposed at this time. That would be, if and when it happens, subject of another application. Counselor? And make sure you're talking to the microphone so that we can hear you at home.
Thank you. Good evening, Chairman, members of the board. My name is Joe Sorgillo, an attorney with McCoy Deutsch, Mulvaney & Carpenter. I'm here on behalf of the applicant, Glengarry Corporation, in connection with this minor subdivision application. As the chairman summarized, this is a minor subdivision application, what we characterized as a merger and lot line adjustment to reconfigure the existing lots 10, 11, 12, 45, and 46 in block 192 into two new lots, which we've currently designated as lot 10 and lot 46, but we will verify with the township tax assessor on the correct lot designation. As the chairman said, there is no development proposed at this time. And this subdivision is part of our ERISA compliance, which we are working with an LSRP for. And I have two witnesses this evening that will address and provide testimony on this application. One is Eric Bogarty, who is a representative of Glengarry Corporation, and the other is Robert Zetterbaum, engineer from RBZ, who will provide professional engineering testimony. The first witness I'd like to bring up is Eric Bogarty, if I may.
You may. And sir, if you please use the microphone there, the handheld mic, or you could use that one if you wish. But
I speak loudly too.
No, believe me. I know in the courtroom it sounds good, but at home they can't hear you.
Okay.
Yeah.
I hope that's okay.
Raise your right hand, please, sir. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. State your full name, spelling your last name.
My name is Eric Bogarty. V as in Victor, O-R-G-I-T-Y.
Thank you.
Thank you. Good evening, everyone. As I said, my name is Eric Bogarty, and I'm the corporate controller for Glengarry. Glengarry Corporation is headquartered in Wyomissing, Pennsylvania. We currently operate 9 brick plants
in Virginia, Pennsylvania, Ohio, Illinois, and Iowa, as well as a man-made stone plant in Kentucky. In addition, we operate 9 retail yards in that same geographic.
I saw it go.
Hope that's not a prediction.
No. We operate 9 retail centers where we sell brick and mortar and other building materials throughout that same geographic area. The company, Glengarry, was established 124 years ago and in Reading, Pennsylvania, where Wyomissing is a suburb of Reading, Pennsylvania. And it's gone through a number of derivations over those 124 years, as you could well expect, but we are currently a subsidiary of Old Castle Incorporated, which is a very large building materials operation headquartered in Atlanta, Georgia. It's a $10 billion company in the United States. It operates in the rest of the world in another $10 or $15 billion worth of activity. Very large. In June of 1988, Glengarry acquired the New Jersey Brick, Shale, and Tile Corporation, which was established sometime in the 1950s. The property that the company owns in Hillsborough is located north of Hamilton Road and east of the railroad lines and west of the railroad line, okay, for general purposes here. There are principally 3 areas that we refer to. I'm going to refer to the original Area A, okay, was 239 acres, which contained the manufacturing facility, warehousing, and our principal quarry area. And that 239 acres is the subject of this hearing, because we're going to ask you to approve a 67-acre subdivision from that 239 acres. We also have 2 other properties which are to the east of the railroad tracks and then further to the east of Sunnymead, with both having access to Hamilton Road. Okay? And those remain as is. There was some minor quarrying work on the one property, but there was never any manufacturing work done on either of those sites whatsoever. As I said, the subject of our hearing tonight is this 239 acres, which I would refer to initially as Area A, which will become Areas A and D if you approve the subdivision. The 239 acres would be broken up into a 67-acre area, which would receive a restricted use designation by the LSRP as part of the ERISA process, and the remaining acreage, give or take a few acres, because Mr. Zetterbaum just finished his survey work, and I may be off a few acres, give or take. But the remaining 172 acres would receive an unrestricted use designation from the LSRP. This subdivision was done at the suggestion of the LSRP, who felt it was best, since the area in question, the 67 acres, would never be developed. It would receive a restricted use, and so as to clean up the situation for the rest of the property in the future, it was felt best to just subdivide that off. So that's the reason we're requesting a subdivision of the property, based on his recommendation. I'd be happy to address any questions that the board might have of me.
So the 5 lots mentioned, 10, 11, 12, 45, 46, together make the 239 acres?
Correct.
And they would become 2 lots?
They would become 2 lots.
Gotcha.
Okay.
Well, no, when it's when it's time for your other witness, he'll show us the map, that's fine.
He'll show you that what's involved there.
Okay, thank you. Questions from the board?
Mr. Chairman, just for the record, let the record note that Mr. Delcor arrived at 7:42.
Thank you. Any questions from the board? Professionals? Bill?
You said your LSRP suggested that you subdivide this off. What are the contaminants that, in this area that we should be concerned about?
The 67 acres?
Correct.
We, as Glengarry, have never tested the site since our ownership. We've never been required to by the state. We have never had a permit and have never conducted any testing.
So you have no phase 1 or phase 2 environmental assessment of the property?
No, because we're going for an unrestricted use designation. There's no reason to have a phase 1. That's something that's normally required by a bank in terms of a transfer of land ownership, and I don't know it to be part of a subdivision request.
Well, I'm just saying, you stated your LSRP suggested, recommended you subdivide it off. I was kind of curious why to subdivide this portion of it off, separate from the rest of it.
The property
what his
has
concern was.
significant wetlands and significant floodplain. Okay, it could never. It's in an undevelopable area. It could never be developed. In any case, you could use it for a soccer field, a baseball field, or some recreational surface use, but that's about all. I mean, you can't develop it for anything else.
Part of this 68 acres, is that part of the manufacturing part of it?
The whole 239 acres, of which this was a part, okay, was part of the plant area, but was never, well, I'm just going to ask my colleague real quick. It was never mined, okay? It was an area that was effectively unused by us. There's been some storage of material there, but it was never mined. There was never any warehousing, never any manufacturing facilities. It was never utilized by us, and I don't believe it was ever utilized by the previous owners.
Just a little concerned. You stated you've never done any environmental testing, but how do you know there are PCBs impacts then?
The PCBs that you may be referring to were as the result of gas and oil stains that were on the concrete underneath the plant and warehouse area, which was on the other side. The cement for the plant floor was broken up, taken away. The land was tested using required standards of the state. It was fully dealt with. You're going to see that as soon as we could get a subdivision here, the LSRP has told us that he will recommend an unrestricted use on that side of the property where all the reclamation was done, and there really wasn't that much. Okay, it was not that much that had to be done there. But it was basically from, forklifts and tow motors and that type of thing that dropped oil onto the ground, or other manufacturing equipment that dropped oil onto the cement. And of course, we had to deal with that as part of the cleanup effort.
That's all I have, Mr. Chairman.
Bruce, you have anything for this witness?
Just a clarification. I'm looking at exhibit sheet 4 of 9, and it appears that the structure to which you're referring is on the property that you are retaining that you wish to develop at some future time.
It's on the property that would be given an unrestricted use by the LSRP. We ourselves will never come before you with a development plan. That's not our business. We would sell it to someone else who would present to you an application for some use.
But just to follow up on Mr. White's question, the PCBs or whatever other contaminants are on the property that you intend to develop, or that someone to whom you will sell this property will develop. Is that correct?
That's correct.
Not on the 67-acre property, but...
That's absolutely correct.
Okay.
How do you know that?
There was never any manufacturing done on that side of the property. PCBs are the result of oil and gas and other petroleum products, as I understand it, okay, which, when you fill your tank with gas at the gasoline station, you're dropping PCBs on the ground if you overfill your tank.
No, you're not. It's BTEX. There's no PCBs in your gasoline.
I thought there were.
No.
There's no
It's
oil.
benzene, toluene, ethylbenzene, and
I stand
xylene.
corrected. I
Your
was told at one time
PCBs
that
are
there
from
was.
transformers, special heat transfer oil and things like that.
From oils, okay.
Yeah. Well, it is an oil PCB.
Right. Okay. From oil, from
No,
petroleum-based products.
Mr. Merninger's environmental engineer. so.
That's fine. I stand, I'm just one of those bean counters, so.
Yeah. Anything else, Bruce?
No further questions.
Eric, did you have anything for this witness? Again, anything from the board for this witness? There is another witness coming. Okay.
Thank you.
Well, no, I do, before you go, though, we do
Sure.
have to open, I know that there's, the public's, it's
Sure,
kind of an empty
sure.
room, but for formality's sake, motion to open to public.
So moved.
Yes, I know you're there, Sue, I see you. Second?
Second.
All in favor, say aye.
Aye.
Any opposed? Open to public. Sue, did you have a question? Okay, see. All right, so,
To close public.
no, not yet, because we have another witness. Now we have another witness. Okay, so, thank you, Counselor, and,
Very much.
okay. Yeah, I guess you have another witness, so.
Yes, Chairman, thank you very much. Our next witness is Robert Zetterbaum.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. State your name, please.
Robert Zetterbaum.
No, use the handheld mic for this part. Yes.
Robert Zetterbaum. I'm a licensed professional engineer and planner, state of New Jersey.
Mr. Zetterbaum, would you please briefly go through your educational employment history as a professional engineer?
Sure.
For the record, sir. we
Okay.
just need to-
I have testified before this board before, but I'm, again, a licensed professional engineer, state of New Jersey since, I believe, 1978. I'm a graduate of Newark College of Engineering. I'm not going to tell you the year because it's a long time ago. I am presently the president of RBZ Enterprises, a general consulting civil engineering firm in Clinton, New Jersey, and these plans were developed under my direct supervision.
Well, sir, the name NCE gives it away because it was already NJIT by the late 70s.
Actually, you do know that NCE still exists within the...
Yeah, that it's a school within NJIT,
Yes.
yeah. Thank you, sir. You may proceed.
Mr. Chairman, just for the record, does the board recognize...
Yes, that's the you may proceed part. Yes.
Thank you, I appreciate that. Well, I will attempt to show you of our exhibits without losing them this time. Now, what I'm referring to is sheet number 4 of the submission that was sent to the board several weeks ago. But essentially, this shows the entire parcel, which is a conglomerate, if you will, of the 5 existing lots, which is 10, 11, 12, 45, and 46. The gross acreage of all those lots is 238.744 acres. Now, our proposal is, and again, if you look at this mapping and you can see the dashed lines of the various lots, this is proposed lot, this is lot 11. Lot 10 is a fully landlocked parcel. We're not exactly sure why it was created or when, but it exists within lot 46. Lot 45 is up in the corner here, but essentially what we're doing is cleaning up this existing situation, putting all 5 lots together, and then subdividing off the approximate 68-acre parcel. When I was retained by Glenn Gary to prepare the maps, I had my surveyors look at the parcel and try to determine what appeared to be a good configuration for what we're calling the new lot 46. We wanted to essentially follow the stream. We did not want to obviously follow a stream, and its natural course, because those change daily, as you know. And we also did not want to create an engineering and surveying nightmare by having something that could not be physically marked in the field. So we've come up with a fairly straight line. We wanted to take the lot back at least past the lot that is presently owned by Hillsborough Township, should that ever be needed for any kind of access to this lot. Again, we don't know who eventually will own it, what it'll be used for, if anything, but we thought that made some decent planning sense. And of course, we wanted to leave enough front to John Hamilton Road to make sure that at least we have proper access to the lot. And that's essentially what created the configuration and the size of the lot that is presently before you this evening.
Mr. Zetterbaum, would you just briefly identify where the existing wetlands and identify where Royce Brook is on that on the exhibit that you created? I'm sorry. And this will be a new exhibit, Mr. Chairman, that's not been previously submitted, so I believe we should have it marked.
A1, I have a sticker, sir.
Okay.
Now, what we're calling Exhibit A1 is sheet number 4 of your set of drawings, but what we've done is we've overlaid onto it the wetland buffer that was established as part of the letter of interpretation that was received on this property and extended through several years from now. Thank you. 2015. Again, this is what the state has established as the wetlands and the buffer for the streams. In some cases, it's buffer from actual intermediate wetlands, and in some cases, it's strictly a buffer from the state open waters that has been designated towards some of the rear of Royce Brook. That also helped us in determining the configuration of the lot line that we were proposing. We wanted to make sure essentially that the lands and obviously were protected. Any portion of the property which is not on the subdivided lot is still being protected by the state mandated wetlands and buffers. So essentially all of the environmentally sensitive areas on the property, be it on the piece of property that will be essentially protected from future development, or the remaining portion, are essentially protected by either the establishment of the subdivision line or the state buffers and wetlands.
And Mr. Zetterbaum, these lots that were proposed in the 2 new lots, they're fully compliant with the zoning regulations and no variances are required in connection with these?
That is correct. There's a fully complying subdivision. There's several waivers that we've asked for, and those waivers are simply because we are not planning to do anything as part of this application. So we've asked waivers from providing things like individual trees or, setbacks and things like that, which obviously would be meaningless for this type of application.
Mr. Zetterbaum, if we can maybe just go through the reports that we received from the professionals and the Environmental Commission in connection with this application. I think we'll go by date, and we can start with the Environmental Commission's report dated April 7th. There was 6 points or comments in this application, or in this report. With regard to item number 1, they speak to the note stabilization of the hill should be considered, which some areas were maybe possibly eroded. The applicant, could you testify that as to whether the applicant will be addressing that comment?
That is correct. Mr. Berry, do you want to handle that?
As soon as the weather is good enough, we'll get someone out there to address those. It's a normal erosion from the harsh winter we've had. So as soon as we get a break in the weather and things are completely dry for a while, we'll have somebody work on it. I believe we've already spoken to someone about doing that, but just hasn't occurred yet.
And And with regard to items, I guess 2 and 5, we have the same response with regard to providing some testing data on the property and providing copies of the documents being prepared by the LSRP. Isn't it true that, or could you please testify to the fact that we will be complying with that when we do have the final report? We will provide the township with a copy, but at this time we do not have a copy.
We don't have a full copy at this time. It's my understanding as part of the LSRP's filing requirements, he'll be sending the township those documents, but if anything has changed and that's not the case, we'll make sure that you do get a copy, irrespective of whatever the filing requirements may be in the state. But we believe he is required to give your township a copy.
And Mr. Zetterbaum, with regard to item number 3, I believe you testified to the basis of why you decided on where that lot line would be located.
That is correct. Again, you know, it was based upon good engineering, planning, and surveying data, and ensuring that the environmentally sensitive areas are covered either by the subdivision line and/or the state designated and approved wetlands and buffers.
And next, with regard to item number 4, that is actually something that's not being handled or controlled by the, this might be better answered from Mr. Bogerty, but the item number 4 talks about groundwater monitoring wells. That's not actually something that's being handled by the applicant, that's being handled by PSE&G, and it's not something we have to provide.
We purchased the property in 1988, and since that point in time, we have never done any testing. Whatever testing was done prior to that time was coordinated by PSE&G, and I suspect that they have, I would think they would have more complete records.
And back to Mr. Zetterbaum, with regard to item number 6, there was a question of whether the proposed lot 46 would be landlocked, and I believe you testified that there is some frontage on Hamilton Road.
Yeah, there's approximately 500 foot or so frontage on Hamilton Road, which is obviously more than sufficient to provide access to this lot.
Okay, I believe that addresses all the comments from the Environmental Commission's report. Moving on to the Mr. White's report dated April 9, 2014. There was 5 general comments identified in there. With regard to number 1, it speaks of the letter of interpretation and the topo for the property. Do you mind, do you address that comment?
Well, again, you know, I did talk to Mr. White on this subject several months ago. I had indicated to him that the topography that we had available was rather old, and we were hoping to be able to use it at least for this portion of the project, as essentially we're not doing anything other than essentially moving around some existing lot lines. In the future, should any kind of development be necessary, then I think the topo would definitely have to be upgraded. But you know, right now we're still using the topo that's 10, 12 years old.
With regard to number 2, we have provided the application number on the revised site plans that were submitted.
Yes, if you look on the title sheet of the subdivision plans, the application number is, if you'd like, we can make it a little bit bigger for you, but I guess that's good. Okay.
With regard to item number 3, we are going to be perfecting the subdivision by deed if approved.
That's correct. I mean, because it's a minor subdivision, we certainly would not be filing, you know, a map on this. This will strictly be perfected by deed.
And we'll provide a meets and bounds description for the engineer's review and approval.
That's correct. We'll be providing a meets and bounds of the post-subdivided lot as well as the land remaining to essentially give Mr. White a chance to review it prior to the filing, and that essentially will, you know, clear up all of the past 5-lot confusion.
With regard to number 4, I believe we addressed the PCB contamination, but as the witness testified, we will provide a full copy of our LSRP report to the township once it has been finalized. And with regard to number 5, as I indicated in my opening, we definitely will be confirming any lot designations with the township tax assessor. I can advise as to the county Planning board application, it's been filed. They did issue a incomplete letter as they were unsure what the term green space meant in our application. I've been in touch with the planner, the planning department for the county, and have been clarified the issue. We have not received our final approval letter yet, or letter of no interest. However, I do expect that shortly, and if the board so approves this application, would ask that to be a condition of approval for final receipt of that. Then lastly, we received a report from the board planner, Mr. Rydell, dated April 9th. I believe we addressed, throughout this testimony, all of his comments. I will actually ask Mr. Rydell if there was anything further that we might have missed in the report.
Through the chair.
I would start by referring to you, Mr. Rydell. Do you think anything's been...
Yes, I would like to thank you, Mr. Chairman.
Yes.
I would like to go back to the issue of the monitoring wells. Given that this is the applicant's property, I believe he has an obligation to find out what's going on his property. I don't think we should rely upon PSE&G. It's the applicant's responsibility to provide that information. Further, on page 204 of the synopsis report, the Raritan and Millstone River Flood Control Commission has comments. That is item number 5 of the report. I think it would be useful if that was addressed by the applicant.
I would ask the applicant now to address the 2 comments made by Mr. Rydell.
Well, and the summarized comment from the Raritan and Millstone River Flood Control Commission indicates that I guess there have been some concern perceived by the residents of Manville that this property is contributory to flooding problems that they have in their town. I don't know if that's well-founded information or not. However, the application before the board tonight is not exacerbating any type of condition one way or the other. I think that is something that may have to be looked at in the future should any development be proposed for either of these lots. But right now, we've got a situation where all we're moving is lot lines. So, we're certainly, and again, I don't know if there's any problems being caused by this property, but an approval this evening is certainly not going to change any existing situation whatsoever. So I think it's a premature comment at this point.
Chairman, with regard to the monitoring wells, actually, and it's something that I apologize we failed to address during our initial discussion of it, but it was actually, those monitoring wells were required as part of a permit that was issued back in 1986, which was thereafter not appealed, but it was thereafter held invalid by the Supreme Court. And by in 1990, the DEP actually revoked that and no longer required monitoring wells. So they're actually, while the monitoring wells are still on the site, they are no longer monitored nor required by the NJDEP. And I can provide I have one copy of the letter I can provide to the board, and I can provide additional copies if so required.
Well, we do need.
Yes,
we do need it for the record, of course.
I apologize, I don't have additional copies with me, but I will submit those tomorrow to the board.
Mr. Bernstein? Any other questions, Mr. Bernstein?
Oh, I'm sorry, Mr. Chairman, if I may continue.
Yes,
please.
Of course. I didn't know you were done. Okay.
On page 404, item number 5C, the applicant has testified as to the intended future use. Perhaps they could provide additional testimony regarding this green space and the open space and how they intend to deal with that property in the future. What the possibilities are that have been considered by the organization?
The property in its entirety is under a sales agreement with a party. I don't believe they've been in contact with the township yet, as it's a very preliminary review process that they're going through as part of our agreement of sale. So it would be inappropriate for me to really get involved with what little I do know about what they might or might not intend. But they'll be coming before this board and other boards of the township, I'm pretty sure, and pretty quickly. The 67 acres, we have had very informal, very brief discussions with the township about the fact that we may be able to, or the future buyer may be able to donate that, contribute it, give it to, however you want to state it, to the township to be used solely for green space. Walking paths, soccer fields, a baseball field, something like that. That's what you could use it for. That's all you could use it for. And I'm sure at the appropriate time we'd have formal discussions if there was interest on the part of the township.
Mr. Merger, do you want to?
Yeah, I'm just biding my time. The Environmental Commission on item number 1 noted this word, the L word that everybody's been avoiding for the last half an hour. It's called landfill. There's a landfill on that property.
On the 67 acres, that's
Yes.
so-called green space, that the idea being to donate to the township, complete with its landfill. Yes, that part.
Yeah, could you address that landfill? And it has to be part of the ISRA process?
No, it does not. It's in an area that's being designated as restricted use, okay? They didn't do any testing there on that side. It's not required to do testing because it's not being designated as an area that would be developed, okay? Our understanding is that sometime starting in the 60s and going through the 70s, early 70s, the township of Hillsborough used the property for a landfill.
Mr. Merdinger, do you have something to say about that?
Yes, I know that you're an accountant, but having spoken to some of your people, the township of Hillsborough has never collected their own garbage. And your own people have told me that they never saw a township truck going in there in the 70s. It closed in 73. But there's bricks on the side of your landfill. It's extended, I was guessing, about an extra 10, 20 feet high, which is a mound system for a landfill. It's almost always the case. But I think you have to address this not as a municipal landfill.
Sir, I was not with the company.
I'm sorry. But as a landfill on your property. It's common for people to call the material that goes into MSW municipal solid waste. It doesn't mean the township owned it or used it.
Yes, the word municipal in this case, in terms of municipal solid waste, designates the type of trash and the scale of the landfill. It doesn't designate that the trash originates from the municipal government, and it does not. So I would ask you again, now that you're under oath, do you know for certain that, or do you claim to know for certain that the township of Hillsborough dumped that trash there?
What I know is that Glengarry purchased the property in 1988.
Mm-hmm.
That we have been told that the landfill, whoever...
Told by who?
By various documents we have, that it was closed in 1973.
Yes.
It was on lot 7A, block 182, which belongs to PSE&G, and a portion was on the New Jersey or Jersey Shale Brick and Tile Company's property, lot 11, block 182.
And
I was certainly not with the company because I only joined the company in 1999, but in any case, the landfill was closed prior to our ownership of the site. The only way this is going to be resolved is to get additional documents from PSE&G, which of course we're willing to try to do.
Have you tried to do that up until now?
Yes, I can testify.
Well, you can testify.
You're an attorney.
But you can tell us something. Go ahead, you can talk, though. Go
As the
ahead.
attorney on behalf of the applicant,
We
I have
understand.
made those inquiries. We have done title work, title searches. We have reached out to PSE&G. Currently, it's difficult to get anything from their department, for the legal department right now. They're under some time restraints and some scrutiny right now.
And when did that process begin?
We've started looking at this probably 2 or 3 weeks ago when we first realized this was an issue that, the town may, and the board may be looking into, and it's an issue that we may have to deal with moving forward. So then we started looking into it. But unfortunately, as of this date, we haven't got anything concrete. The only thing we have is from some letters back and forth from 1985 that references, the landfill being operated on these two properties, but nothing recorded of record, no lease agreement, nothing from the PSE&G, any agreement or any designation of what that was actually used for, or who had rights to it, or what actually happened there. Just a few letters that were received from our due diligence when we purchased.
So prior to the application process, it didn't seem to be important to have background on the landfill?
We're not looking to do any building, or we didn't really think so, because we're just looking to change the lot lines and subdivide, so we didn't think at this time we would. Obviously, moving forward, if there was any development, or if there was any negotiations with the town for or anyone else for a transfer, that was going to be very important, something we'd have to deal with. But for the purpose of this application, at the time, we didn't think it was an issue that we had to address now. But as the process went along, we realized it's something the board was looking for some information for, so we tried to get it before this evening, but unfortunately we're at this stage.
Well, when you make representations that maybe the township would take the piece of land, it's important to discuss what's on the piece of land, because on behalf of the taxpayers, the township does not want to take on, and who knows how many dollar obligation to clean up a landfill. Mr. Merdinger, I know you got something more to add. Go ahead.
The word closed was used. You have to understand, in landfill terms, there's a proper closure to landfill. From what I can tell, that has never been done. And so it may have not been used anymore since 1973, but there's a lot of things you have to do with a landfill, including the methane gas, the leachate, and the wells that you have to put in around there, and then the proper cover. So all these factors obviously have never been done as we are hearing tonight, and looking at the landfill, it's kind of obvious too. So this is something that you're going to have to address in the long run.
Oh, and we understand that. We absolutely understand that. And even with regard to, we threw out the idea of donating or, granting this property to the town, but it was only an idea. There was only one option that we could use for it. And I think that kind of got wheels of its own. But obviously, if that was the case, and we have a committee person here this evening, that would be something that would have to be fully negotiated and talked about, and would have to be addressed if that even went forward. It could be something that's just not feasible, or something the township's not interested whatsoever.
We have never had any formal discussions.
Deputy Mayor.
I apologize.
I'm just curious, if we don't want it.
Don't think.
What if the answer is we don't want it, you're stuck with it?
That's what it is today. This subdivision really has nothing to do with the.
Actually, the cat's out of the bag. The horse already left the barn. You already said that you have a potential sale agreement, and part of that sale agreement is we're going to give you this space.
No, that wasn't part of the sales agreement.
No, that's not part of it.
Option that the potential purchaser may do. That's not something that's.
Okay.
The sales agreement covers the entire property.
All 239 acres.
All 230, actually all 348 acres.
Oh, right, because you have those other
two parcels as
right,
well.
that are not here, right.
Okay,
Yes,
never mind.
gotcha.
I withdraw my comment.
All right, so, all right, well, you can tell your buyer that the township's quite aware of these issues, and that's fascinating.
Not gonna have an easy
Mr. Julian, I know that you need to talk from behalf of the Environmental Commission, of which you are a member.
Mr. Chairman, before Mr. Julian.
Yes.
May I?
Yes,
I
certainly.
don't mean to interrupt him.
No, that's okay.
But it somewhat addresses what I suspect Mr. Julian, on behalf of the commission and himself, are going to raise. Council indicated to you all that the monitoring wells do not require monitoring, for lack of a better phrase, because the permit that grants such was invalid and therefore there hasn't been nothing done. And he provided a copy, he provided a letter which he will provide a copy to the board about. If the board will indulge me for a moment, I'd like to read the letter.
Yes, please.
Because I think you're going to need to hear the whole letter. It's regarding the landfill name, Hillsborough Township SLF, New Jersey Pollutant Discharge Elimination Service / discharge to groundwater permit number 0057959. It is a letter from Arnold Schiffman, the Assistant Director of Groundwater Quality Management at NJDEP, dated February 6th of 1990.
1990?
Correct.
Okay, right.
Pursuant to the New Jersey Supreme Court decision in Vi Concrete Company versus State of New Jersey Department of Environmental Protection, the above referenced New Jersey Pollutant Discharge Elimination System / discharge to groundwater, NJPDES / DJW permit, which addresses the landfill at your facility, has been determined to be invalid effective April 19, 1989. This determination is based on the department's understanding that the subject landfill closed prior to January 1, 1982. If the landfill closed subsequent to January 1, 1982, you have an affirmative obligation to notify the department of the actual closing date, period. If the letter ended at that point, we'd have one situation, but the letter doesn't. The court's decision is without prejudice to the future issuance of a new or replacement in GIPD's DGW permit and the associated fees. The decision does not affect any conditions or requirements of the existing permit which address other regulated units at your facility. These conditions and/or requirements remain in full force and effect. Additionally, the court's decision does not affect other applicable legal obligations to undertake or continue a groundwater monitoring program and/or any other preventative or remedial actions which may be required by other existing laws. Final paragraph. Presently, the department is drafting groundwater regulations which may affect the subject landfill. Therefore, we recommend that you maintain any existing groundwater monitoring wells constructed to monitor the landfill and continue to implement any groundwater monitoring program which has been instituted at the landfill. Sincerely, Mr. Schiffman.
Have fun.
So, yeah, I mean, just to take off on that, the GIPD's permit has nothing to do with the landfill closure. So one thing's apples and oranges. So, but just let me go back to the Environmental Commission's report, which was pretty comprehensive. And I know you touched on a few of the items, but I want to rehash some of the points here. So it was a two-part report. One was from the meeting, and one was from the site walk. During the meeting, the applicant did identify the landfill, and exactly what we're talking about here. We didn't recognize that there were, any test methods that were current in terms of the groundwater monitoring. So we'd certainly like to see updated test methods in terms of the groundwater monitoring. When you talk about like delineating lines here, so it's very hard to recognize where the pollution actually is here. So we have a landfill. We're trying to redelineate lines, but we're not quite sure where the pollution is flowing to. So before
let's
we
back up a little bit. Let's not the board use the term pollution. Have we deemed that there is any pollution?
We don't know.
We haven't. So let's try.
Yeah, we
not
don't
to
know
do
that.
That's kind of like a liability.
Right.
So.
But I guess what we're saying is we won't know that until we see any test results, which we don't have.
So on the record, we don't know if there's any pollution.
We don't. That's what we'd like to find out.
Is that something we need to know before we get the line?
Well, we're gonna deal with that before we vote. That is a question we will ask of our own counsel.
Right.
for certain.
I would think it'd be something that we would discuss once the site plan comes.
Yeah, that may be, and, well, I mean, you're bringing it up, it's a good point. Eric, what's your thoughts on the relevance of this to the issue before us versus its legal relevance in any future development application?
I think that any action that the board takes relative to this subdivision application does not necessarily prejudice nor impact upon any site plan application that comes before you. However, I think the board does have the right to request some of these reports and materials in whichever form they exist from whomever prior to anyone submitting any application for any development of this property, whether it's by Glengarry or by a subsequent property owner who then comes before you and says, if I had only known, I would have done those things, but since I didn't know, I can't. It's if Glengarry is going to sell this to somebody else, whoever buys this needs to be under the knowledge that if we don't have it before then, we're going to need to have it when they come to visit. So,
I was just going to say, so, but relative to the application before us, if we do or we don't discuss these issues, it still doesn't, we're not being.
I believe.
And we're not hurting ourselves. Or
I don't believe we're hurting ourselves. On the other hand, I believe the concerns and issues raised by both the Environmental Commission and by Mr. White relative to items that need to be addressed should either be addressed to the extent the applicant can address them, or the board needs to address it in any approval resolution, so any existing applicant or future applicant for this site is aware of the fact that it is a matter that needs to be addressed prior to any application.
So just for the record, then I think we're talking about at least 3 different areas of testing. I think we're talking about, I think we're talking about sediment that was brought in from New Jersey, American Water. I think we're talking about groundwater monitoring wells for the landfill. And I think we're talking about any test results for the upcoming ISRA, as well as any PCB contamination.
Wouldn't it all be covered under the LSRP when they do the investigation?
Well, I don't know. If it's going to be deed restricted, I'm not sure what testing will be conducted or not be conducted. That's something that's an unknown at this point. I don't know.
I thought that you made a representation that that's not being done now precisely because the lot that this is on is being deed restricted, which strikes me as an excellent reason to deed restrict it so that you can somehow not end up going through all of this testing and find out what you don't want to know about it. Mr. Merdinger, any other? Yeah.
I just to comment on Mr. Burchett's comment, because we've already had testimony, they're going to try to avoid everything, as the chairman was saying. I think it was important that we press the point to make sure the LSRP does cover it. And that's important.
Well, LSRP is a new thing from when I was in the field. But is it the same as an SI? So in other words, it's going to be encompassed.
Well, remember, an LSRP is a person. It's an individual.
Well, it's also a methodology that.
Yeah.
It's a from what I understand, it's a conduit to the DEP in terms of they're going to make the decisions and represent the DEP.
Not a DEP employee.
Yeah, but it's also a methodology.
Yes.
So
you have to go through the site investigation and it's a whole punch list. And you're right about that.
I just question that at this point, if we're going to move a line for the purpose of deed restricting a piece of property, I'd like to know, what's on that property with some, qualified information, which we don't have. That's my point. That was the point of the Environmental Commission.
Greg, I think it's highlighted by the fact that the applicant has indicated the reason they are moving the lot lines and they are deed restricting the property is because there are environmental issues on the property which they want to avoid, and for lack of a better phrase, contaminating the clean property for purposes of the subdivision and or future sale.
Well, we don't know if there is anything.
Well, there is something.
We can't say that it's contaminated.
But Greg, that's the point. We don't know because
exactly
that is the point.
And equally importantly, Greg, the word contaminated was not used by anybody here first. It was used by the applicant, who indicated that one of the rationales upon which the property is being subdivided is to separate A from B. And B apparently is a concern, either because there are contaminants that the applicant believes exist on it, and/or which may be on it vis-a-vis the monitoring wells, the existence of somebody's landfill, whoever that may be, and related items at least raise the question. It may ultimately turn out that there is nothing there that meets the criteria. However, I think it's in the best interest of the board to at least put everyone on notice that when this goes forward, and apparently it is going to go forward, that whoever brings it forward, whether it is this applicant or another, needs to understand what issues this board is going to want to hear about in advance, to the extent the material exists. If PSE&G has it, if NJDEP has it, and the letter that seems, for example, on the monitoring wells, it seems to indicate there's no requirement for such, in typical DEP fashion says, but you should continue to still have your monitoring wells and continuing your monitoring provisions.
Yeah,
and
Mr. Bernstein, I think that was talking about an Egypti's permit, not the closure of that landfill, which is two separate issues from what I understand.
But still interrelated.
Okay.
So I don't disagree that in reality it may ultimately turn out that it is not environmentally challenged. We won't use that other word. But I think this is more a precautionary situation because the applicant is not in here just moving lot lines for the purposes of moving lot lines. They've clearly indicated as part of their application, and council can correct me if I'm wrong anywhere along the way here, that they have come in here to move the lot lines for purposes of a subsequent sale and development of the property by a third party yet to be determined.
Oh, they determined it, we just don't know who it is.
Well, yeah, apparently still yet to be determined.
Mm-hmm. Okay.
I'm confused. Guys, you're a business, and please don't take this wrong, but you're spending a lot of money to come up here to move a property line. And I don't understand why. I have yet to get a good reason to why you want to move this. I understand you got a whole bunch of lots, but why all the expense? I mean, I don't get it. I really don't.
Because the person who wants to develop and make tons and tons of money, some of which they'll share with this business when they buy the land, wants to separate the problems from the...
That's the
yeah.
I mean, I want to hear from them the reason for the property line.
Well, even if you were to, let's talk about two facts, okay? You keep denying that there's any problem here, and the fact is we don't know. So we can't deny it, we can't confirm it, we can't deny it, but we can confirm two things. Number one, there's a landfill of some type on the land that's being divided off, all right, which the suggestion had been, oh, well, maybe the township would like it. Number two, there's a lot of wetland on that site. Both of those things would be impediments to development. So clearly, it makes perfect rational sense that a future developer of this property doesn't want the part of the property involved in their application, which has a lot of wetland and which contains a landfill. Now, I don't know what's leaching out of the landfill, if anything. But that's the point, we don't know. But the obvious thing is to separate issues from parts that have fewer issues, because there is some wetland on the other part. But that's pretty clear.
Mr. Chairman?
Yes.
May I suggest that in light of Mr. Burchett's request that the applicant address the question asked?
Yeah,
which
absolutely.
Is why is the applicant here seeking a subdivision line change?
Yeah.
I think I stated up front that those entire 67 acres are undevelopable. And wetlands, floodplain, and there is an area that was established sometime in the past as a landfill.
Which you didn't state in your original presentation, by the way. And that's also a matter of the record. Please.
Okay. It had been discussed a number of times with a number of people here present.
Could you close that briefcase?
What's that? Sure. As such, that area, which under any other circumstance, even if the landfill wasn't on it, is undevelopable. Given the fact that the landfill is there, it was just deemed by the LSRP to simplify matters, to designate the whole area as restricted use and segregate it off. That was their proposal. We followed along with his proposal.
But aren't you under contract for the whole thing?
We are.
So then why the subdivision now?
Yeah, why won't they just have the applicant come forward and ask for the subdivision on their own dime?
Or why even
Because we want to finalize the LSRP process, the ERISA process, okay? And finalize that process.
Could you explain the ERISA process for some members of the board who may not know what they're talking about?
Okay, I'm somewhat a novice, but we applied in 2008 under ERISA, okay, to close the site. We did various testing, and we're required to do certain remediations. The area where the factory itself was, where the cement was, where there was oil and gas and other contaminants spilled on the concrete over 50 years. That was all handled. It was all tested. The LSRP has all those test results. The soil was tested. The LSRP has all those results. Whatever fill was brought on site, okay, was all done under New Jersey proper permitting standards. The LSRP has all those results, which are numerous and many. You know, I don't know how thick a stack it is. But he has all that. That's all part of the LSRP record. Okay, so whenever that's finally submitted to all the appropriate authorities, one of which is the Hillsborough Township, I believe, okay, they would all get that information. Okay, including all the testing that was done on the site by the LSRPs or the ERISA process by various consultants and reviewed by the LSRP.
We see sites here all the time that have areas on the site that have green and have other problem areas, and they just treat it as one big site. They don't come to us to segregate it off. Why can't we just treat it as one big site?
Because you wouldn't get an unrestricted use on everything to the west of that new property line, okay? You
So
have
that's the reason you're coming for the property line?
They would have to,
That's what I was looking for. I want to know
Right.
why you're coming for property. You're doing a lot of
that
money.
area would, as I stated before, the area west of that new property line that represents D would be given a unrestricted use designation. Everything to the east of that property line, okay, in lot D, I think it's now referred to, would be given a restricted use designation, which means it could be developed.
So-
And it couldn't be developed for a number of reasons, and not, you know, one of them being there was once a landfill there 40-some years ago.
Why do you think it would get deed restricted? Because of the landfill or because of the wetlands? Why would it?
It was already undevelopable because of the wetlands and the floodplain. Under any circumstance, that entire 67 acres couldn't be developed. You couldn't build on it because it's
Then still
restricted.
keep it one big lot and you just don't develop over there.
That's not how the ERISA process works, as I understand it, and I'm a real novice here. I don't know if my colleague
But again, we
could
see
add
sites
any light
here
to
all the
that.
time where that area just wouldn't be developed. It'd still be one site. As representing the town, this is what I'm worried about.
Sure.
Now we go ahead and separate that off. You've got that clean site. Your new buyer is going to come in and say, hey, I want to do something on this side. Now it's going to make it more difficult for us to take care of what is on the other side. If there is a landfill, if there is, I'm not saying there is anything, you know, but if there is something going on, it's going to tie our hands because it's a separate site.
Plus, we never saw the ERISA report that recommended that specific delineation in terms of the floodplain and the wetlands. I mean, that's...
In my opinion, let's do some investigation and then come back to the board.
Well, they never point. The issue, And you're waiting now for the LSRP report, but it seems as though you're saying that this is to be done to conform with what the LSRP wants, but we don't know what's in the LSRP report, so why would we move forward with a plan without understanding the implications of the full report?
I'm not sure I follow the point, but...
We're having a hard time following the whole thing. Because as Greg, as Mr. Burchetta said, Deputy Mayor Burchetta said, and I think most of us are thinking the same thing, is, like you said, that if any applicant comes before us, let me put it this way, let me put it better, I guess, I wanted you to say it on the record one way or another, is that, do you or do you not know for sure, or for certain, or is there anything in writing between you and this potential buyer that states that this sale is contingent on lopping off that piece of property, and they don't want anything to do with it?
No, there is nothing in the contract that makes the sale conditional.
How about a verbal? How about a verbal?
Absolutely, positively not.
I know, I'm not doubting you, but I'm just making sure you understand that when that particular applicant comes to us,
The entire sales agreement, okay, is for the entire 348 acres.
All right, thank you for your answer. Appreciate it.
Yeah, I think the point is more that when you see this next, right? If we do this, when you see this next, you're not going to see that lot.
Right.
It won't be there. It'll be, oh, that's not part of this application. That's irrelevant to this application. And you'll see the other part, which they'll have all the documentation has been cleaned up and, you know, and certified, stamped, cleaned up and all that. And this part you won't see. You'll never see it again.
The thing that I'm worried about in terms of future, long-term future, is there's many ways for a town to wind up being stuck with a piece of property. It doesn't necessarily have to be given to us and we accept it. It could be foreclosed upon, it could be abandoned, and the town is forced to take it over. There could be litigation. You know, there's all many ways, right, Eric? We can wind up being stuck with it 20, 30 years from now.
I think the major reason why the board is concerned about the issue at hand is because it's the basis upon which you've made this application. You stated in your application as well as in your testimony that the reason you are here tonight to make this lot line change is because you've been advised by your LSRP that this is the way to go. I think the board has considerable question as to how that was determined, in my words, in a vacuum. There is nothing from the LSRP saying this is why I'm recommending it. There is no report that indicates what the basis for such is. It is the applicant's contention that having been told by an LSRP that we should do it, we're asking you to do it, you being the board. And I think the board does have a right to know, based on that request, how that request came about for purposes of redoing the lot lines.
And I would say, I would add, you know, to you, I would say something else. Let's assume that lot line, and it's not what it actually looks like what it does, because it looks like there's a fair amount of wetland on both sides of the line. But let's assume all the wetland was on the east side of the line and was in the property being. Let's assume the line wasn't there and that wetland was in a large piece of property and a developer came to develop it. They would just simply propose a development that avoided that piece of land, right? There'd be no reason for them. So I don't understand why, and maybe someone, Mike, can help me, why would an LSRP say that the entire site would be restricted because part of it's wet? I don't see the reason for that.
With all due respect, I'm going to suggest Mr. Merdinger not answer the question.
Okay.
Not because he's not qualified in his own right to answer it, but it's not his to answer.
Okay. So I have a question.
I think the answer is, Mr. Chairman, having made this representation for purposes of the application, you're absolutely correct. There would be no potential difference if an applicant came here and said, I want to develop this site as developed with the existing lot structure, and these are the places I cannot develop, and the engineers and all the professionals would say where you can and can't. The applicant has come to you indicating a request to do so based on an underlying premise, which I believe the board has the right to understand what the underlying premise is versus the questions that I think almost
Okay,
everybody
fine, I will ask this to the
has
applicant.
raised,
I will ask
which
this
is
to
why.
the, yeah, I will ask this to the applicant. The applicant bring whatever witness they want to answer it. On what basis would an LSRP say that you have to section off a part as restricted simply on the basis of it being wet, when people come to get development on pieces of land that have wet portions all the time? And that doesn't make them restricted, doesn't make the other parts, the non-wet parts, restricted from development.
If I didn't make myself clear initially, I'll make myself clear now. It's one, because the entire 67 acres cannot be developed, okay? And two, there's wetlands, there's floodplain, and yes, there was a landfill established by someone some 50 years ago, which has been closed for 40 years, okay? We were told by the LSRP to segregate that out so it doesn't become an issue with respects to the rest of the property, which he could provide an unrestricted use designation because all the testing has been done and all the appropriate standards have been fulfilled.
So why can't he provide an unrestricted designation for these 67 acres? Are you going to tell me that because a lot of it's wet, that he can't make them unrestricted or part of unrestricted, or is there another reason why he can't make them or designate them as unrestricted?
If I may clarify that, or correct that answer a little bit further, is the LSRP's rationale for saying...
Well, wait a minute, this is testimony now, which you really shouldn't be given. Now, if you wanted to find another witness for me, that's fine.
No, I'm actually asking...
Oh, okay, no, I'll ask him, go ahead.
The 67-acre lot is been designated or requested to be sectioned off by the LSRP as undevelopable is not just because of wetlands, but for other...
No, I'm not interested in the part of it being undevelopable. If all 67 acres was a swamp, it would be undevelopable, that's fine. I want to know why it is restricted when in fact it's not all in green, and why does it need to be divided out? Because the reason to divide it out can only be one logical reason, that if it's not divided, it would make the entire parcel restricted. So what about that piece of land would make the entire parcel restricted, such that it needs to be divided out in order to contain the restriction? And are you going to tell me that the reason is, well, some of it's wet?
No, I was getting there. I was just getting to the first point that for the witness to testify to the fact that it's not all restricted just because it's wet. Is that correct?
That's correct.
So there are other factors that affect the 67 acres that besides being wet that make it undevelopable?
That's correct.
Okay.
Even if the landfill wasn't there, the entire 67 acres is undevelopable.
But if the landfill wasn't there, would those 67 acres make the entire site restricted? That's my question.
Mr. Chairman?
I can't give you a specific response.
There you go. Yes?
Mr. Chairman, with all due respect to all the questioning, there's a missing piece to this questioning.
Sure.
And let me tell you what the missing piece is.
Yes.
The witness is not an expert.
True.
And what we are having is we are having testimony based on understanding, and the gentleman has clearly indicated exactly what his position is, what his qualifications are, and what he can and cannot tell us. He is telling us, however, giving us what I would indicate is very close to expert testimony on an understanding with nothing before this board that the board can review or question anybody about regarding such. It is also my understanding that the testimony of the one individual who does have a certain amount of expertise on this situation has indicated that in the document which is currently on the board is A1, those are the designations of the wetlands in accordance with the permit granted by DEP, which clearly do not indicate that the entire so-called subdivided lot is wet. Right. So, with all due respect, Counselor, does the applicant intend to provide either documentation or a witness or both who can testify as to why the recommendation for this board to consider is happening other than a representative of the company who is relating what I would euphemistically refer to in the legal business as hearsay testimony for purposes of the situation at hand.
To answer, Mr. Chairman, if I may, to answer the board attorney's question, it was very poignant and it makes a lot of sense based upon the question.
I think it was very pointed, not poignant. But go ahead.
We would, if the board would be willing to carry this application to another hearing date, we will arrange to have the LSRP here to answer any additional questions.
May I also suggest, Counselor, that in advance of his appearance here, that he provide any and all documentation and reports that he intends to rely upon for purposes of his testimony to the professionals on behalf of the board and the board, so the board can have an opportunity to review such in advance of his testimony.
Yes, we will provide what we can. I know some of the documents are in draft form. They are not prepared to be presented. However, all documents that can be produced.
So let me say it a little bit clearer, just so we're all clear. Before he comes and presents, we want his full report.
He can't finish his full report until we get this subdivision, is at least what we're told from him.
So
that's
the reason I raised my hand. From what I understand about the LSRP process, is that he's not going to be able to testify until he's complete.
Well, let's put it this way. If that's the case, we need to know that in advance so the board can then address whatever it chooses to address in terms of the purposes. The problem is we've got the proverbial chicken and the egg situation. The applicant has come to you telling you that he's being told to do something, asking you to certify the doing, based on a representation of an individual who needs to be before you to give you the basis upon which he's making it, which he may not be able to do because he may not be able to testify in advance of the situation. If that's the case, by the way, then the applicant has the obligation to advise you all what he can provide, if any, and why he can't provide what the board is seeking, and then the board can then make its decision accordingly, which is to grant or deny the lot line.
Exactly.
Yes.
So I think the applicant has indicated a desire to carry the hearing.
Right, the applicant also said they could produce the LSRP.
Yes.
They did say that.
Yes.
But can they? They may find out they can't. Mr. White?
Well, you know, there's a difference between producing the person and producing the person's final report. It may be that you can't have his final report, but you could produce the person.
And
Which one is it?
Yeah, Mr. Chairman, if I can clarify what I said. You know, the final report might not be permitted. We can permit all the data that might support it, but we won't be able to commit the final report because that won't be completed at the time. That's what I was getting at. I apologize.
I think also that I'd feel more comfortable, because the LSRP program is such a new program, that I'm not sure who knows what in terms of this LSRP issue, and it would be nice to have someone from the state verify what the LSRP can and can't do. So I'm not quite sure that anybody here has that expertise to do that also.
I was going to ask Mr. Martinger a question. So is there another way to move forward? I mean, does the LSRP have to have a plan that says they can't issue a report until it's contingent upon?
No, but it's a matter of his client.
Our counselor said not to answer.
Mike?
Yes, I'm sorry.
My suggestion is, I'm not putting this on Bill because it's Bill, I'm putting it on to the extent that it probably will have to come from the engineer anyway relative to what the process is, versus a board member who, though, is expert in the field.
And an LSRP.
And an LSRP cannot, however, provide what ostensibly is testimony.
Yeah, that's what's difficult for us, Mr. Bernstein, is that we know that we have a board member who is an LSRP, and it's difficult not to actually ask him about his position.
He's just protecting.
Yeah, that's fine, and that's fine. That's for your benefit,
I'm concerned
Mike.
about a future record.
I understand.
Yeah.
I do have one item that I want to make sure when the LSRP comes or the report comes. The second item of the Environmental Commission noted the fill from New Jersey American Water, and it was already testified that the area is being, clean fill is going in the area, but this is a test area that they're using this. And as a test area, it's not clean certified fill. So what happened on number 2 is they're asking for the testing on that. And basically, that's something I think we want to make sure. And I think, if I have it right, that fill is being used on lot 46, proposed lot 46, not on your cutoff. Am I right about that?
The materials in question were originally brought in to the Lot A side, okay?
A is 46, correct?
A is
Well,
the
46 is
remaining
your
172 acres.
A is the bigger piece.
A is
the bigger piece.
So that's your
It was
developable
brought, it was brought in there under full permitted standards by the state. We have all those documents. We have all those documents.
Permit
and
is
we'll-
based on, I talked to our health officer, Dr. Glenn Belning. A permit is a test permit, which means it's being tested and they're making sure. But again, we've already proven that you're not an environmental expert, so that's okay.
Okay, if I may
I'm
ask.
only saying that
Yeah.
whatever materials were brought on site were permitted, tested before they were brought onto site, okay? That's a fact, and those documents are part of the LSARP's record, part of our records, okay? Some of that material was transferred to what would be Lot D for the man who was running the operation to finalize for lack of a better word, he was mixing products together to sell it as fill, but it was never used to fill the site.
Oh, that was...
It was never used to fill the site. It's
That
only...
was presented to me that way when I...
That's incorrect. That's incorrect. It was never used on that side to fill the site.
Okay.
There was some of it used on the far side, okay? Whatever is existing on the 67-acre side is just his efforts to get rid of the final amount to make it into topsoil and sell it.
So he's commingling. What was the material that American Water, a water company,
It's
was
their
trying to get rid of?
sediment, and it's
And
sediment
clarifier?
typically is from the Millstone River. They can draw, this is on Westland Canal Road.
Right.
They can draw from both the Millstone and from the Delaware-Raritan Canal. But the Millstone has much more sediment and turbidity, so that's where they like to draw from the canal, but you can't suck too much out of the canal. So they're drawing from Millstone and getting more sediment.
We'll see what the paperwork says.
Yes.
Okay, Mr. Bernstein, so the applicant requests...
How long do you believe, Counselor, it's going to take you to get what you need to do to come back before the board?
And I do suggest that your LSRP look very carefully at our Environmental Commission reports and provide everything being requested, as well as whatever was requested here today, if there was more than what was in the report. But to your question, Mr. Bernstein, when would this be?
Well, I'm asking the applicant how long he thinks it will take him. If he wants to spend a couple of minutes conferring with his client, he can. Can I suggest we take a 5-minute recess, Mr. Chairman?
Do you need a recess?
Can you dismiss the board?
No, I think we would need
Okay.
a month's time to be able to collate all the documents, assure that all the appropriate information is there, and make all copies and provide it, and then make sure that the LSRB has enough time to keep the schedule clear.
Bruce, what do we have in May then?
We have a full meeting on the 8th of May, Country Classics.
Yeah, that's
Preliminary
full
final
meeting.
plus South Branch Estates.
Uh-huh.
The next regular board meeting would then be June 5.
June 5. That's plenty of time.
Yeah, absolutely.
Okay.
We will definitely have that.
Do we have to vote
Yes.
Okay.
So that...
Mike.
I'm
Not
so
necessarily.
sure.
Let Mr. Bernstein
I'm not so
say it.
sure there's a need for a renotice of the situation. Do we need to grant an extension, is Mr. Rydell? Applicant's willing to sign an extension through June 30th?
Yes.
Fill in the magic date. The request, Mr. Chairman, is to continue this hearing. This is application 14 PB01MR, block 182, lots 10, 11, 12, 45, and 46, to June 5th, 2014, without further notice.
And to accept the request for an extension to
And
June
request for
30th for the whole...
extension to June 30th for the entire application.
Is there a motion for that?
So moved.
Second.
Okay, roll call, please.
Mr. Wagner?
Yes.
Mr. Julian?
Yes.
Mr. Shawn?
Yes.
Mr. Connor?
Yes.
Mr. Merdinger?
Yes.
Vice Chairman Cohen?
Yes.
Committeeman Delacour?
Yes.
Deputy Mayor Burchett?
Yes.
Chairman Dr. Seuss.
Yes. Very good. So, June 5, we'll see you back here then.
Thank you.
Thank you.
Thank you.
There being no further business, unless you, oh, wait, yes, Bruce? Meetings, right. What is it we don't have business for again?
April 24 business meeting and May 1st regular meeting.
Okay, so there's no activity for the April 24th business meeting or the May 1st regular meeting. So can I have a motion to cancel those meetings?
So moved.
Second.
All in favor, say aye. Aye. Any opposed? Okay. Huh? They are canceled. And is that it now? We're done? Okay, so we'll see you at the next regular meeting of May the 8th. Motion to adjourn?
So moved.
Second? Second. All in favor, say aye. Aye. We are adjourned.